employers. This presentation will last about 30 minutes. A recording of the webinar will be available on the Wagner Law Group website shortly, and you can access previous webinars on the website as well. Let me introduce our speaker, David Gabor, a partner with the Wagner Law Group in the Boston office. Welcome, David.
Thank you, Barbara, and thank you all for joining. October is National Disability Employment Awareness Month. This is an ideal time to introduce a program designed to help employers navigate issues surrounding disability and leave law. We will focus on some of the rights and obligations created by the Americans with Disabilities Act and the Family Medical Leave Act. Please understand that there are many state and local laws and other federal rules and regulations that govern the rights and responsibilities of employers and employees concerning disability and leave laws. It is also important to recognize that the Equal Employment Opportunity Commission, the EEOC, actively protects employees claiming disability discrimination based in part on a strong public policy promoting return to work. As a result, we are going to help you to anticipate potential risks and prepare in advance for issues that may arise. And a predominant goal in the program is to avoid unpleasant or unwanted surprises. So why does this matter? No litigation is pleasant. The cost, the time, the risks are simply put a huge challenge. And over the past few years, there have been many high-profile discrimination cases based upon disability. For example, the bipolar disorder employee who won $1.2 million plus legal fees. There was an $8 million verdict for a blind worker. He had a job he could perform if he was given something called a JAWS, job access with speech. It was an inexpensive way to resolve the problems. He even went so far as to make the employer aware of this and also that he had filed a claim. So what did they do? They gave him a sham interview designed to force him out the door. There was a $7.5 million verdict for a man with cerebral palsy. An HIV-positive worker recovered $1.25 million. And then there was a company that conducted blood tests, and they didn't disclose why they were doing the blood test, and they got hit for $2.2 million. So let's talk about some trends. These are examples of ADA discrimination, a refusal to provide a sign language interpreter at company meetings for a very large multinational organization. They asked disability-related interview questions, and then they fired an employee because they had an epileptic seizure. A third company presumed that the employee needs to have two hands to have a job as a busboy, and therefore they would not hire this person to work for them. And that was actually a restaurant that served sushi. A fourth case where a person was fired because they asked for periodic leave because they had hepatitis C. A fifth case, placing obstacles designed to hinder the return to work. Sixth case, there was a diabetic who had diabetic retinopathy and asked to have a magnifying glass so she can read. The company said no and fired her. And finally, believe it or not, there was a man who had a brittle bone disease, and as a result he had to use a wheelchair. So he asked for an accommodation. Can I have 5 minutes more at my lunch hour because it takes me longer to get in my chair and get down the hall and get back? The company said no. Can you imagine that? And then last but not least, we really don't want to be subject to EEOC press releases. It's bad press and it really hurts the business, and it also calls in question whether we're doing our jobs well. So let's talk a bit about the laws that are involved here. The ADA and state laws are designed to help disabled people get to work if they're able to do their work, possibly with some kind of accommodation. So they focus on a failure to hire, a failure to promote, whether an employee is subjected to a hostile work environment, and also are people being treated in a disparate manner. We also have the Family Medical Leave Act, and that covers employers with at least 50 employees, and the employees have got to be working for a year on a full-time basis, which is based on 1,250 hours over the course of that year. Those covered employees are entitled to up to 12 weeks of leave. It can be taken at one time or over months or even the full year. There are limitations on what is appropriate leave, and these employees are entitled to return to the same or a substantially comparable position at the end of leave. So briefly, FMLA leaves cover the birth of a son or daughter, and also, by the way, an adoption, a serious ill family member, spouse, a son, a daughter, or parent, or a worker's own serious illness, and you do have a right to ask for documentation to confirm that this employee is ill or their family member is ill. Now, there's also USERRA, which provides that service members are also protected, and that's for a service member, a family member for, who's going into deployment, and they get not just the 12 weeks, they actually get 26 weeks of leave. So the first thing we're going to talk about is updating our policies. Make sure that we are current under the ADA and the FMLA. There are changes in the laws, there are changes in best practices. Take the time to make sure you are current. And also keep in mind that there are a lot of states, for example, New York and California, and New York City is a local law, that heavily regulate things such as disability laws and notice requirements. There's also an issue that does sometimes arise where maybe something doesn't sit well under the ADA, but it might be covered under Title VII. So there may be a time where if you look at it from the perspective of one law, you may be missing an issue. And really important, make it work for your organization. One size does not fit all when you write your policies. One company may be better to go to HR. Another company may want to go to the COO. There might be different ways to handle this situation in your company, and take the time to make it work for you. One of the areas that so often results in litigation is communication. So you write a great policy, but it's really not all that great if nobody knows about it. Be sure to disseminate your policy. Be sure that your employees sign that they've received the latest draft of your policies. Train the employees. Make them aware of their rights. And then keep records of the training. Keep those in both two places. One, the employee's file, where they sign, acknowledge that they attended, and then you can have a separate folder for training and have a roster of all the employees who attended, and they sign in and they sign out. Train and coach managers in advance of requests. And this is important. The manager needs to know what to say if an employee comes to the manager and says, I need leave. If they don't know what to say, they may say something that's wrong. Because, for example, a manager who's under pressure to meet a deadline and finds out that a key employee is going to be out on leave only thinks, oh my God, how am I going to meet that deadline now that Gabor is out? So coach the managers in advance on what to say. And also, training has got to be consistent throughout the organization. You shouldn't have a different training program for one place and another place, with the exception maybe of recognizing a local or state law. And be careful about disparate treatment. This occurs when, for example, you've got 3 employees who all are asking for leave. One of them is 55 years old, the other 2 are 35. And the company says to the 35-year-olds, sure, no problem, take your leave. But to the 55-year-old, they say, you got to show up to work. Well, that person now is going to think age discrimination. And be careful of retaliation. When a person asks for leave and anything bad happens to them afterwards, they are going to argue that they were the victim of retaliation. At least potentially they can argue that, so please be careful. Let's talk about the interactive process. When an employee seeks an accommodation, then the employer and the employee should engage in an interactive process. And it is not necessary for the employee to say, I am looking for an accommodation. If an employer knew or should have known of a need for an accommodation, then the employer has a responsibility to initiate the interactive process. During that process, the employee is going to say, I need an accommodation. Let's say I need a wheelchair ramp. The employer might say, well, that's fine. We'll put a wheelchair ramp in. Or the employer might say, we've got no way we can do that. But listen to the employee. Make the employee feel respected throughout the process. Have an open mind, and don't come across an employee like you've already decided that this employee will get no accommodation no matter whether it is or is not reasonable. If the employee feels that way, the employee is likely to find a lawyer. So let's talk about reasonable accommodations. Job restructuring. Maybe, for example, an employee can't lift, but they can do everything else. So another employee might not be able to bend, to do filing because of herniated discs, but the employee can do every other part of the job. You can restructure the job. Making existing facilities accessible, like, for example, the wheelchair ramp, or a stall in a bathroom that is wheelchair accessible. Sometimes it's possible to put a person on a part-time or a modified work schedule. Maybe a person, because of a major family issue, can't get to work at 8 o'clock in the morning, but can get there at 9. And dependent upon the job, maybe you can modify the schedule for that purpose. Sometimes it comes down to modifying equipment. If there's an employee who is deaf and you have TTY communication equipment, or if a person is deaf, you put a flasher or blinker on the phone so they know that the phone is ringing. Changing test, giving a bit more time for an employee who may be ADHD to complete the test, or training materials. Qualified readers or interpreters. Many cases now involve people, for example, who need to have an interpreter because they're deaf and the company refuses to provide the interpreter. And if there is a vacant position, we can put an employee in a vacant position, and that is a way to accommodate them. However, many courts have said you don't have to reassign the employee to another position if it's filled by somebody, because that would be an undue hardship on the person in the position. So there are some takeaways and tips regarding the interactive process and the accommodation. One thing is, if HR grants the accommodation, believe it or not, there are times that they forgot to tell the manager, yeah, Laura is taking this accommodation, and they don't tell the manager writes Laura up. Have a contingency plan if there's a different manager. Greg is a manager in a different group, and Greg is going to manage Laura because the manager is out. He has no idea about the accommodation, and he writes Laura up. Now Laura's crying retaliation. Make sure the interactive process is confidential as much as humanly possible. We have HIPAA violations that can come out if we start telling people that a person, let's say, for example, is bipolar or manic or ADHD or has cancer, whatever the issue is. And we live in a real world. As much as the legislature and the courts sometimes think it's very easy, word gets out there, hey, why is Laura coming in at 9 instead of 8? There's got to be a way to communicate to people that Laura will be coming in at 9 o'clock due to a change in her schedule without telling the world why. And for goodness sakes, please document the process. If any of you remember the honeymooners, when I walk in front of a judge and they ask for documentation to show that we engaged in the interactive process, and I've got nothing, and I feel like I'm Ralph Crandon, and all I can do is say, hamana, 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 it doesn't really look good for the company. So please document the process. And also be careful, as I said earlier, for those claims of disparate treatment, when you are more lenient in granting an accommodation to one person as opposed to another. Now, safety programs, and you may be saying, why is Gabor putting safety programs into this webinar? The answer is simple. I think safety programs are great. You know, we don't want people getting hurt if we can help. We want to have clear, mandated policies and procedures, protective equipment, so we can reduce the risk of injury in the workplace. And with injury comes costs, especially if you're self-insured, absenteeism. It puts at jeopardy the timely delivery of goods and materials. So safety programs are great. So why is he talking about them? Well, it's simple. If there is a bonus attached to a safety program, so for example, if we have no injuries for 6 months, everybody gets $500. That sounds wonderful. 6 months, no injuries, nobody hurt, no absenteeism, morale is up, everyone gets their $500. What if there is an accident? And now all of a sudden, we've got somebody who made a mistake. Barbara got hurt. Now everyone's going to be mad at Barbara. They might bully her. There might be peer pressure. Do not report this. You know, I don't want to lose my $500 because you hurt yourself at work. Someone may even rough her up. There becomes dissension. Now Barbara's friends are going to be angry at people who are threatening Barbara. And all this leads to risk and exposure. So if you are going to do a safety program, please do not attach a bonus conditioned upon safety. Back to work. This has been an issue in several high-profile cases over the last couple of years and even earlier this year. If the company has a policy that can be interpreted as restricting the ability of an employee to return to work after a leave, that policy will be subject to scrutiny. And for example, there was a company recently that had a policy that said that you don't come back to work unless you're 100% recovered. Another company had a policy that said you can only come back to work if you can perform every job within your job description fully and capably, and we need doctor's notes to support that. What these blanket policies did is it discouraged people from coming back to work, because maybe I can come back to work with a minor accommodation, or maybe I can come back on a part-time basis. But because of the language in the policy and the letters they were sending out to these people, they never came back to work. As a result, they brought claims of discrimination, and they were successful in these cases. What we need to do is, when an employee is ready to come back to work, meet with the employee, whether it's by phone or in person, and on a case-by-case basis determine whether they're fit to come back to work. That is what the EEOC expects. That's what the courts expect. Now, oftentimes, we enter into a balancing act where we've got clients or customers that we depend on to pay us money to run our businesses. And there are concerns sometimes that these customers or the clients, excuse me, don't want to work with somebody who is visibly disabled. For example, there was a security guard who a company said to the company that the security guard worked for, we don't want him on our property. We don't want a one-armed security guard. Well, he went to court and he won. The court said, we don't care what the customer says. That employee has a right to a workplace free from discrimination, period. And the same is true if an employee is being treated in a hostile manner. There are cases where, for example, a person is deaf and a vendor came in, and the vendor used to sneak up behind the guy and pour water on his head or hit him in the back or put a kick me sign on his derriere. Courts don't like that. You have a right as an employee to a workplace free from hostile work environment or other forms of discrimination motivated by your disability. Now, the Office of Federal Contract Compliance Programs governs federal contracts that corporations enter into. Some of you in the audience today may be involved in federal contracts. If you are, there are certain mandates that have been defined recently. One is a utilization goal of 7% for IWDs, individuals with disabilities. Contractors have to apply the goal to each of their job groups or to their entire workforce if they have less than 100 employees. Data collection. The contractors must document and update on an annual basis several quantitative comparisons to establish that they are making a concerted effort to hire the IWDs. They have to self-identify, which means that a person who is disabled has the right to say before the interview and after the interview, if they're offered a job, that they are a person who is disabled and able to do the job with or without a reasonable accommodation. If you're dealing with a subcontract, you have to specifically indicate in the subcontract that this agreement is governed by the Equal Opportunity. Further, the OFCCP has the right to review your documentation to confirm compliance, and you have to be aware of the list under the ADAA of what is a covered disabled person. Here are some tips. Understand before you go into a government contract that you're going to have obligations beyond what you already have based on the ADA, the FMLA, and state and local laws. Now, if you do go into contracts, during the course of the year, audit yourself to make sure that you're compliant. So, for example, if you've got a deadline of November 1st to file a form, don't wait until October 15th to start to gather your data and make sure you're compliant. Do it throughout the year. And if you have to make adjustments, and you're doing those adjustments 6 or 9 months in advance, you're in a much better position. And understand the public policy that the government is under huge pressure to get people back to work, even if they need accommodations. So oftentimes they're going to err on the side of pushing people back to work, even though it may create some semblance of a burden for you. Now let's talk a bit about job descriptions. One of the things that oftentimes arises is we create a job description, and let's say this is for an admin, and we say the admin's got to be able to lift 25 pounds, or maybe even 35 or 40 pounds. Well, is that reasonable? Do you really need to have an admin lift 25 to 35 or 40 pounds? Think about it. Think about whether the job descriptions are properly tailored to the job, or they're arbitrary, or maybe they've just been that way for 15 or 20 years, and take the time to audit. Same with typing. For example, some jobs, people really don't need to be able to type at a certain pace. So you might have a person with carpal tunnel syndrome or a person with cerebral palsy who can do everything but the typing, and you're not going to give this person a job or let them continue to work there because of the typing. Walking. Not every job requires that you're able to walk, but sometimes it's in job descriptions. You must be able to walk for 30 minutes. I've seen it. I don't understand why it's there, but it's there. The second thing is that many of the cases recently that have come down oftentimes are the product of a presumption that a person is unable to do the job because of their disability. So, for example, a delivery person who is deaf was not given a job delivering because, oh, a deaf person isn't able to do that job. If they walk down the street, they might get in trouble. They might get hurt. Well, they walk to work every day. If they can walk to work, why can't they walk down the street? And the courts didn't buy that. You know, there's an example that I love to give in programs about an assumption. This is a guy named Jim Abbott, played baseball at the University of Michigan and then for several major league teams. He was born with no right hand. Now, how the heck is he going to play baseball with no right hand? Not only did he play baseball, he was a pitcher. He won the Golden Spike Award in college, and he even threw a no-hitter with the Yankees. So how can he do this with one arm and one hand? He had a way to pitch the baseball, put the glove on his pitching hand so quickly that he was able to field pitches. He even had 2 base hits at the major leaguer with one arm. So sometimes it's actually in our benefit not to assume that a person can't do it because of a physical limitation, but actually we may have a great person coming to work for us, even with that limitation. So take the time to audit the job descriptions and actually what the people are doing to make sure they do match up and they're reasonable and they're necessary. If a concern exists, let's say, for example, a presumption that a person can't do the job, move towards an interactive process. Ask for a letter from a doctor. Have your own doctor examine the individual. And if there is an accommodation that's necessary, you may find that there are public funds available to help. There are organizations that are promoting getting people who are blind or deaf or amputees to work, and they may pay money to help support the accommodation. And then document. The last topic, number 10, is the concern about disparate treatment and retaliation. I know I mentioned both of them earlier, but it does bear repeating. Make sure your organization is not exposed to a claim of disparate treatment. And the way you do this is you record the request for accommodations and the way the company handled the accommodations. You keep those records in human resources, and you audit them to make sure that we're not developing a statistical anomaly. Let's say, for example, people over 50 aren't getting accommodations, or women, or men, or people who are of a different minority. And keep in mind that any employee who's looking for an accommodation or is coming back from leave needs to be protected from a concern about retaliation. The new standard defined by the Supreme Court, but for the time on leave, the request for the accommodation, I would not have had X, Y, and Z happen to me. So that's what you need to do. So let's make a checklist. Number 1, update your policies. 2, make sure your policies are disseminated. 3, train your team and coach your managers. Now, during the course of the year, maybe you have a training in February, someone becomes a manager in April. Is that new manager being coached? That should be a new checklist. Prepare in advance for the request for an accommodation or to engage in the interactive process. Know who will be involved in the process. Note that the managers will give the right response whenever the request is made, and know that they will preserve the confidentiality. If you've got a safety program in your company, make sure that you do not structure it to reward people if there is no claim or injury over a certain period of time, for the reasons I said earlier. Have a return to work program that resolves each request to return, again, on a case-by-case basis. If you have a blanket policy and it's too stringent, you're exposing yourself to litigation. The right to a workplace free from discrimination or harassment includes third parties such as vendors, delivery people, repair people, customers, and clients. And even if their wishes put you at risk of potentially losing an account, you can't ignore the employee's right to a workplace free from discrimination. If you are doing federal contracts, create a schedule regarding your compliance that's a 12-month schedule, so you're not leaving it all for the back end. Audit your job descriptions. And finally, every once in a while, audit and make sure that you are not treating people in a disparate manner and that you're training your employees about retaliation. And thank you all for joining me for the program today. I hope that I gave you some ideas that will help you with your companies and avoid problems. And also, by the way, I am doing a program at 2 p.m. on November 7th about contingencies that happen in the workforce. And this, the idea for the program came about because of a question asked by a client about how to treat employees that they were concerned might be exposed to Ebola virus disease. So we're going to talk about how to handle employees with Ebola virus disease and also other contingencies that could occur, given that we're heading towards the winter and what happens when we've got a blackout, a snow event, etc. So please feel free to join me on November 7th. And again, thank you for attending the program today.
Thank you, David. That was very informative. And thank you to everyone for attending this webinar. A recording will be available on the Wagner Law Group website shortly, as well as the PowerPoint slides. There were a number of questions, but we don't have time to answer them, but David will be in touch with you with the answers. If you
yes, please.
Go ahead.
I'm sorry, Barbara. Yes, please feel free to, forward the questions to me, and I'll be happy to answer them.
And if you didn't have a chance to write it in the chat box, please feel free to contact David. His contact information is up on the screen. And thank you very much.